Good morning, everybody, and thanks for coming. We have 90 minutes. Emanuela-Chiara Gillard is with us, and some of you may know Manu from previous events and conversations and the excellent work that Manu does. So for those who don't know Manu, she's the Senior Research Fellow at the Oxford Institute of Ethics, and previous chapters of her career included Chief of Protection of Civilians Policy Department in OCHA, and legal advisor to the ICRC. So this morning, we're going to discuss Security Council Resolution 2664, the importance of that, the regulatory framework around it, what it does, what it does not do, and the scope of the exemption of the resolution. Manu will also touch on where we are now and how humanitarian actors should be using the progress, the practical day-to-day engagement with the resolution, and also what to watch out for and what comes next in terms of advocacy and really making sure that this resolution is useful to the work of humanitarian actors. So as I said, the presentation part of this is recorded, then we will stop when we come to Q&A. But I think given the topic, Manu is welcome for people to just jump in and ask questions, or if you want to put your question in the chat, and we'll make sure that that's part of the conversation. So thanks so much for joining, and thanks Dominic for being up so early in New York, and to Suraj, it's late in the evening in South Korea. So Manu, over to you, and thanks for joining us this morning.
Great. It's really a pleasure to be here and to be back with you. As I was preparing my talking points, I remembered the first time we had a similar conversation. And Rachel, I now can't remember whether it was 3 or 4 years ago, but it was at the time that Ireland was preparing for its bid for the Security Council seat. And I cannot overestimate how important the conversations were. What a privilege it was to have this conversation with the Irish NGOs, and your also phenomenal engagement with the Irish government, because Ireland took the challenge of trying to find ways to resolve the tensions between sanctions and sanctions and humanitarian action as one of the issues it was going to champion at the Security Council. And what a champion it has been. It's just been amazing. We were well aware of the problem. We were also aware of the potential solution, which is a matter of the letter of the law is quite simple. But the politics at New York level of finding a solution. And I think we were all saying, if we manage to find an exception, to include exceptions in a few more sanctions regimes, that'll be phenomenal. That will be such a valuable precedent. And I think to everyone's surprise, here we are with 2664, a cross-cutting exception across existing and future UN sanctions regime. It's really far, far more than anyone ever dared to hope for. And in fact, I'm on record for saying there will never be a cross-cutting exception. That's just not something the Security Council is ever going to agree to. I am so happy to have been proved wrong. But again, I'm really delighted to be speaking to you, because I think you played a colossal role in helping Ireland make the case at New York level. And it's really been the relentless engagement of humanitarian actors on this particular issue for 10 years that have got us to where we are today. As we'll see, we're in a very good place with regard to UN sanctions. It's been fascinating to see how this pendulum has been swinging between New York, Washington, and Brussels as to who's leading in implementing the ways to resolve the tensions. At the moment, it's Washington and DC and New York that are ahead of the curve. Brussels is lagging a bit behind, and that's going to be the challenge going ahead. So congratulations and thank you. What I'm going to do is first kick off with a presentation on the normative framework, the regulatory framework, as a matter of the letter of the law what has this resolution done? Then open up for a discussion on that, and then turn perhaps to more of a policy advocacy discussion, what needs to happen next. I'm Italian, I have children. Interrupt me whenever you want to ask a question, when there's something that you don't think I have been sufficiently clear about, please interrupt me. I've just realized that I'm seeing myself, but not you so much. So Rachel, whenever you see such a question coming up, please interrupt me with it. So let's take a step back and just remind ourselves of what is the problem that Security Council Resolution 2664 addresses. Financial sanctions. Okay, we're Irish, I can't see it. You've already interrupted me. Okay, this is going to be fun. What is the problem that 2664 addresses? It's financial sanctions that it's focused on. And financial sanctions prohibit making funds or assets, things, commodities, available directly or indirectly to persons or entities that are designated for the purpose of the sanctions. What's the problem? Incidental payments that humanitarian actors may have to make in the course of humanitarian action to designated entities. So, for example, payment of fees or licenses, or humanitarian commodities that are diverted and end up in the hands of designated entities or persons, as a matter of the letter of the law, fall within the scope of the exception of the prohibitions, and absent adequate safeguards would violate the sanctions. So very much a tension between the prohibitions and the realities that sometimes we might have to make payments to designated persons or entities, particularly when they exercise a governance role, or that there are diversion of goods and assets. So there's very much a clear problem. How has the problem been addressed until now, until December of last year? And I'm talking for now at UN level. For 11 years, the Somalia financial sanctions were the only UN sanctions regime to include a safeguard that expressly excluded payments made or assets provided in the course of humanitarian action from these prohibitions on making funds or assets available. This was introduced in 2010 because Al-Shabaab was designated for the purpose of the sanctions. Clearly, they exercise extensive control over territory. They have a governance role to a degree. There was a real problem with the sanctions. So there was an express exception introduced there for funds or assets that might be provided in the course of humanitarian action. For 11 years, that was the only express exception. Things changed in December 2021 after the return of the Taliban to power. Even though the Taliban are not themselves designated for the purpose of UN sanctions, a number of the ministers that were now heading up ministries were personally designated. There was a lot of confusion. Does that mean we cannot make payments to these ministries? I have my view on that, but it doesn't matter, because very much there was a need for clarity. And clarity is always the name of the game when we talk about sanctions. Why we're concerned, our donors are concerned, private actors such as the banking sector, insurances, everyone's concerned. So to the extent that we can have useful clarity, great. So the Security Council adopted a broad exception in relation to the sanctions in Afghanistan in December 2021. And we saw the tide beginning to turn. Hey, Ireland's on the council, because Haiti sanctions that were adopted in October of last year from the outset included a broad exception for funds or assets provided in the course of humanitarian action or activities to meet basic human needs. So we were seeing the pendulum begin to turn, or things beginning to turn. The council was willing on a sanctions regime specific basis to actually include exceptions. And then in the summer of last year, 2022, the US put forward this cross-cutting exemption. Very wisely, it partnered up with Ireland from the outset, I would say, and this led to the unanimous adoption of, no, it wasn't unanimous, it was 14, India abstaining. Anyway, Russia voted in favor, which is quite amazing, adoption of Security Council Resolution 2664. So what does it do? It introduces a broad express exception applicable to all existing financial sanctions in UN sanctions regimes. It also applies to future UN sanctions regimes unless the Security Council expressly decides otherwise, which is amazing. I've never seen the Security Council be willing to bind itself in the future, but this is what it's done. So again, phenomenal, but let's understand what it covers. It covers financial sanctions. It does not cover other types of restrictions in UN sanctions that may affect humanitarian action, such as the restrictions on the import of certain commodities, for example. Safeguards with regard to these other restrictions will continue to have to be negotiated sanctions regimes by sanctions regime. That hasn't changed. And I'll come to this in a moment. And also, and I'll keep on repeating this, but it's important to bear it in mind, the exception only applies to UN sanctions. It doesn't apply to additional autonomous sanctions regimes that other actors may impose, such as, for example, the EU or states autonomously like the US and the UK. It doesn't apply to those. I'll come to that in a moment. I can't see whether there's any hands up. Okay, I'm going to keep going. So let's, with this in mind, we're looking at financial sanctions adopted by the Security Council. What activities does the exception cover? And it's important that we frame it correctly. It's not that the exception authorizes humanitarian activities or activities to meet basic human needs. These were never prohibited in the first place. And at risk of sounding pedantic, it's really important to bear this in mind, because so many times, I'm just thinking in Afghanistan, so many times I'd hear people say, oh, are we allowed to carry out this particular humanitarian activity? And I'd say it was never prohibited. Sanctions don't prohibit the humanitarian activities. What financial sanctions prohibit is making funds or assets available directly or indirectly. Problems arise because in the course of humanitarian activities, some of these funds may be made available. So it's important to understand, have this framing in mind. So what does the exception authorize? It authorizes the provision, processing, or payment of funds, the provision of other financial assets or economic resources. And economic resources is essentially everything. All things, anything that can be sold. So economic resources is commodities, and the provision of goods and services. All of this is not caught by the prohibition if these are necessary, and this is what's important to bear in mind, to ensure the timely delivery of humanitarian assistance or to support other activities that support basic human needs. So any funds or assets that we make available or that end up in the hands of designated persons or entities, if these are necessary for the timely delivery of humanitarian assistance or to support other activities that support basic human needs, it's permissible if carried out by a broad but not unlimited list of actors. So what do we have here? The Somalia sanctions only covered humanitarian funds or assets provided in the course of humanitarian assistance by a list of actors. The Afghanistan sanctions were actually, the exception in Afghanistan sanctions was broader. It covered funds or assets provided in the course of humanitarian assistance, activities to meet basic human needs, and it didn't specify which actors. The cross-cutting exception does specify the actors, and it is a broad list of actors, and I'll come to them in a moment. But first, what constitute humanitarian assistance and activities to meet basic human needs? The Security Council hasn't specified this. Good. Why? Because the Security Council is a political body that is not very good at coming up with legal definitions. It's also very likely that the moment it defines something for political considerations, it'll end up coming up with something crazy and narrow. So it's great it hasn't defined it. What can we say? The exception in the UN Somalia sanctions was limited to, as I said, humanitarian activity, but this in practice was interpreted extremely broadly to cover all the activities in, I refer to the humanitarian response plan, it's probably got a different name now, but essentially all the activities covered by that, which are definitely more than just life-saving humanitarian. Obviously the sanction covers, the exception in 2664 is broader than that because it starts off with humanitarian assistance and then adds activities to support basic human needs. Where does this language come from? Activities to support basic human needs. As far as the UN Security Council is concerned, we see it in the Afghanistan exception, the exception to the Afghanistan sanctions. It was in there, not defined, good, I always say, but where did it come from? Before it was there, it came from the US, the US's own exceptions to the Afghanistan sanctions. And there we find a lot of clarification provided by OFAC, which is the part of the Department of Treasury, US Treasury, that implements sanctions, and it's provided a lot of very helpful guidance, including as to what constitute activities to support basic human needs. Essentially, it's development activities, maybe not building the bridge that links Sicily to Italy, but definitely development activities, including sustaining essential services, preserving social investment, and community level systems essential to meeting basic human needs. So the understanding, at least by the US, is that it covers development activities. Now, for political reasons, it was not possible at UN level to include the D word in the Afghanistan sanctions. And some states also expressed reservations about how this notion is to be interpreted when it comes to 2664, those states notably being France. And this is going to be relevant going forward. But I know this, Gisela knows this, Dominic knows this, but it's not in the public record, luckily. In the explanation of vote, France did not say this, which is helpful. So where does that leave us? It leaves us with a broad exception that's definitely more than just humanitarian assistance, because there's these additional words. There's an understanding that it should cover development action. It's not the Security Council that implements 2664, it's individual member states that do so. So please, let's not get the Security Council to define it because we're going to hit France very quickly. It's states that give effect to UN sanctions. I'll come to that in a moment. The activities of which actors are covered. And as I said, the exception in the Afghanistan sanctions was framed only in terms of the types of activities. 2664 is a combination of that and of the Somalia sanctions, in as much as it lists the actors who might be carrying out these, who might be making the funds available in the course of their activities. And it's a broad list. It covers the UN, including programs, funds, and agencies, specialized agencies, and related organizations, international organizations, not more defined, humanitarian organizations with observer status at the GA Assembly and their members. That's essentially the ICRC, IFRC, and national societies. I saw the Irish Red Cross is here. First time that that national societies are expressly covered, which is important. Then, and this is really, really broad, the bilaterally or multilaterally funded NGOs participating in the relevant UN HRPs, humanitarian response plans, other United Nations appeal or OCHA coordinated humanitarian clusters, and their employees, grantees, subsidiaries, or implementing partners. So it's really, really broad. We would really, while negotiating this, trying to catch as essentially everyone who's a meaningful actor. And I think that really odd language, bilaterally, multilaterally funded NGOs participating in the response plans or the coordinated clusters, was really intended to catch everyone. I'm always wondering, does it catch MSF? I actually think it doesn't anymore, because unfortunately the word bilaterally or multilaterally funded was inserted at some point. So it's always the MSFs of the world that are difficult to catch, because they're none of the other things. They don't have they don't have General Assembly observer status, and they don't receive funding from states. But it's apart from MSF that unfortunately doesn't seem to be caught at present. I would struggle to see which other key humanitarian actor responding, key NGO responding, isn't caught either in its own capacity or as implementing partner subsidiary of someone that is caught. So it's actually very, very broad. That's what the exception covers. What has not changed, and I've already said this earlier, as far as UN sanctions are concerned, 2664 only relates to restrictions in financial sanctions. Other types of restrictions that can adversely impact humanitarian action remain unchanged. This could include, for example, restrictions on imports of certain goods, as in the case of the DPRK sanctions. In relation to that, the procedure for authorization remains unchanged. This isn't what 2664 is about. It could be restrictions in arms embargoes that prohibit the imports of military equipment and vehicle dual-use items, for example. And here we're still on the sanctions regime by sanctions regime basis, while some sanctions regimes do, UN sanctions I'm talking about, do include safeguards that allow the import of non-lethal military equipment for humanitarian use of protective clothing, both of which are necessary for demining activities, for example. So definitely already the NGOs responding, carrying out demining activities are saying, okay, work's not done as far as we're concerned. Not all sanctions regimes currently do. How long will the exception last? There's no time limit on the exception itself, nor a prescribed time limit for reviewing the arrangements, except with regard to the ISIL al-Qaeda sanctions. And this, again, was essentially the price to pay to get France to come on board. And with regard to that specific regime only, 2 years after the adoption of 2664, so 2024, the Council will decide whether to extend the application of the exception. One last point on the law is how does it work? The exception has immediate effect. However, it's member states, it's states that give effect to the exception, and whether additional instruments are necessary or not very much depends on the domestic legal arrangement of every country. I'm going to stop here perhaps before I then give you both a quick update on what's happening at EU level in terms of implementation, and also what you need to do as humanitarian actors.
Great, thanks so much, Manu. We'll take a few minutes if there's any questions or clarifications at this point.
It states, with regard to this with regard to sanctions generally and with regard to the exception itself, it's states that give effect to it. Now, the truth is that there are some actors that assiduously both implement UN sanctions and the exceptions thereto, and there are many, many, many UN member states that don't, just simply don't across the board. That's not our problem. Good that they don't, you know. But obviously they're the key actors that do. And who are the key actors? It's the EU, it's the US, it's the UK, it's Australia, it's Canada, key actors in the sense of donors, and also the actors that are important from a banking perspective. So as far as Ireland is concerned, what's particularly important for us is what happens at EU level. Why? Because it is the EU that gives effect to UN sanctions for itself and also for EU member states. It's the EU that adopts the necessary instruments, which once adopted at Brussels levels by the 27 member states have direct effect in the law of the 27 EU member states. So what has happened is that the EU has given effect to 2664. 14th of February, it adopted the necessary EU legal instruments, so a European Council directive and regulation, to get technical. It has adopted them, which means that as of the 14th of February, the exception exists as a matter of Irish law. Now, I have my old notes, and my old notes were careful, we've got to keep an eye on what's happening at Brussels level. We don't want them to somehow narrow the scope of 2664 when giving effect to it in EU law, because technically as a matter of law, it could have done so. It could have said, yeah, fine, this is what the Security Council says, but we are going to adopt a more stringent approach. And therefore, all of us would have had to immediately try and jump on to this and say, no, don't do that. There's some legal and humanitarian principle reasons why the Security Council has adopted this type of exception. Luckily, this didn't happen. I say luckily because paradoxically, it's easier to know what's happening at New York level and to influence states at New York level than at Brussels level. Brussels, at least for me sitting out here in Rome, but also when I'm liaising with states, suddenly becomes a bit of a black box. So it's very difficult, I find, to influence Brussels. We'll come to that in a moment in terms of what happens next. But again, talking just of 2664. So in as much as the EU was giving effect to the 15, I think, but not all of them might have financial sanctions. So the number of UN sanctions that include financial measures, to the extent that the EU has implemented them, they now all include exactly the same exception. So as far as 2664 is concerned, we're in a very good place. Concerns allayed. What other states have done so? The UK has done so. I think it was the 23rd, no, it was the 9th of February. And again, the UK replicated 2664 in terms of the activities and the actors concerned. Same. The US was the first to actually give effect to 2664. It did so before Christmas, 21st of December. And interestingly, it did so both for UN sanctions, but also for a number of the autonomous sanctions that it had adopted. Some, but not all. It's really something that needs to be looked at on a case-by-case basis, to the extent that you receive US funding and therefore have agreed to comply with US sanctions. You really need to look at each sanctions regime and say, okay, what has the US done? Has it implemented 2664? And how has it implemented it? Because it hasn't actually replicated 2664. It's taken different approaches. In fact, it's narrowed it. No one's really picked this up yet, but it is. So we'll perhaps park the US for now and flag some other things, but maybe we can come back to a focused conversation on the US. So again, coming back to the EU, what's important to bear in mind is that, sorry, I'm smiling, Niall, because you have a very expressive face and you're not looking convinced. I don't know how to get you off my screen, so so what's important to bear in mind is that the EU has only to date given effect to 2664 for UN sanctions. So for all the other sanctions that the EU has adopted autonomously, that include financial sanctions, such as the Ukraine sanctions, the Syria sanctions, all the others, we are exactly where we were the day before 2664 got adopted. It hasn't changed at all. Perhaps we'll come to this in a moment, because to me, this is a key area of humanitarian diplomacy and potential that's ahead of us. Let's go back to 2664. What does it require? And this is something that's important to bear in mind. A number of NGOs have kind of said, oh, great, okay, I'm done. I don't need you anymore, Manu. And I'm going, okay, that's not quite right, because yes, there's this authorization to make funds or assets available to designated entities, but ideally don't do so unless you have to. So if you actually look at 2664 itself, it calls upon the actors that rely on the exception to nonetheless use reasonable efforts to minimize the accrual of any benefits prohibited by sanctions to designated persons or entities, including by strengthening risk management and due diligence processes. And we had similar language in the Afghanistan resolution. And, you know, this makes sense, but it makes sense not just in terms of sanctions, it makes sense in terms of good humanitarian programming. There may be payments that unavoidably you need to make to designated persons or entities. I'm jumping a bit, I'm jumping to EU sanctions, but for example, EU sanctions, Hamas is designated under EU sanctions. If you have to pay taxes to Hamas, for example, it's unavoidable, you can't avoid it. I actually think there's a difference between Hamas and the structures, the various ministries, but let's say there isn't clarity on it, you have to pay taxes, there's no way around it. However, there are other payments that you don't want to end up in the hands of designated persons or entities. That's just bad humanitarian programming. You are going to take measures to avoid diversion anyway, because that's just good humanitarian programming. And then there may be other situations where there is a payment that could go to a designated person, but you can avoid it. There are other options. So I'm saying there are no options to paying taxes. However, if the designated entity, a designated entity is a particular company that, for example, is a key telecommunications provider and you are using it for your own services, is there another company that you could use? Is there an alternative to using a designated one? If there is, try and use that one. It's a question here of, while the letter of the law would allow you to make the payment, for reputational reasons, avoid it. For building trust with the states that are giving you these exemptions, say, look, to the extent that I can avoid making payments and therefore undermining potentially sanctions, it's not going to be the payment that you make that undermines sanctions, but it's a game. There's got to be a quid pro quo, there's got to be a trust, we've got to show that we are taking measures whenever we can to avoid making the payments, then do it. So again, I'm giving a bad example because it's the Syria sanctions and these are EU sanctions and there isn't an exception, but the example there is Syriatel, for example. Syriatel is designated for the purpose of EU sanctions. Try and see if there's someone else that you can use. So it's not the end of the game. It's not that suddenly we don't need to worry about sanctions anymore. And it's important to continue to collect the practices as we've done in the past. Until now, we've said, look, these are the problems. These are the measures I have taken to try and avoid making the payments. This is all the due diligence that I take anyway. This payment I avoided making. This one was inevitable. So I think this very constructive conversation needs to continue happening. Now, how you carry it up is up to you. If you look at Security Council Resolution 2664 itself, it actually introduces 2 new briefing and reporting obligations within the UN system. First, there's an annual briefing by the UN Emergency Relief Coordinator to each sanctions committee, explaining on the delivery of humanitarian assistance, on any diversion of funds, and to risk management and due diligence processes that are in place. So this is to each one of the sanctions committees in New York that have adopted financial sanctions. And then more broadly, there's a report by the Secretary General due in September on the unintended adverse humanitarian consequences of Security Council resolutions, Security Council sanctions more broadly. I'd say both documents are something we should be taking seriously, because I keep on saying it's a quid pro quo. We, as I was saying with the banks, build trust. You can't afford to say, no, I'm not going to give you that. This is an opportunity to build trust, but we've got to be careful. It's a fine balance. Obviously, for a start, the sanctions committees are not humanitarian experts. They're not legal experts. So yes, they need to be familiarized. God forbid, I'm not going to say educated, familiarized with humanitarian action, what it is, what it isn't, and also with the multitude of measures that humanitarian actors take to avoid diversion. I've been working on this file for 10 years, and I find it staggering that frequently I speak to sanctions experts and they're surprised that you take measures. And I'm like, well, that's just good humanitarian programming. So it's an opportunity to highlight these. How do you do it? Do you provide information to Ireland? You might be more comfortable saying, I'm going to provide information to Ireland so that Ireland is aware. Or you might say, I'm going to provide information to OCHA because it's OCHA preparing the briefings. I'm going to provide information to OCHA at field level. I'm going to provide information to OCHA at New York level. You know how these things work. And I always say, it's an opportunity we can't miss. We've got to play the game. We've got to do our side of things. And I think that we've been lucky in terms of relatively low reporting back obligations. I see Dominic has a comment on this. A really important but possibly separate conversation is review of sanctions, of review of designations, opportunities to feed into these processes at New York level and also at Brussels level to say, I mean, ideally before sanctions are imposed, far harder to feed in before designations because these are meant to be surprise, but there's general comments that we can make as humanitarians. For example, don't designate groups as a whole. That's far, far more problematic. Designate individuals, same political impact, far less cascading effects. It's a really important conversation, having a list of issues that the actors that impose sanctions, be it the Security Council, the EU, should be aware of. All of those, that dimension of the conversation needs to happen, let alone the far more existentialist points that you were raising about sanctions shouldn't be operating in a vacuum, but they're frequently the sole instrument that we see today. So, but just to go back to what the Security Council 2664 says, I think the SG's report is an opportunity because it expressly says it should include recommendations for minimizing and mitigating unintended adverse consequences, including by the adoption of additional standing exceptions. This is an opportunity. I would say it's a nudge. It's to look at other restrictions. So not financial sanctions, but imports, for example. I know that I've spoken to MPA and they were saying we have problems with all our demining work. We're going to try and, obviously 2664 hasn't helped us. This could be an opportunity. So I'm always saying, look, take the opportunities that are there. So, right. So what does it mean for where are we now? What does it mean? I'd say in terms of your operations, as I was saying, I think there is this exception. I don't think that, as far as UN financial sanctions are concerned, I don't think that it means, okay, great, I don't need to check anymore. I think as a matter of due diligence, you will check anyway. You're going to avoid making payments if these are not strictly necessary. There's no reason why you should suddenly start using a vendor that's designated if you can use a different one. So definitely work to be continued in terms of ensuring you comply with UN sanctions anyway. I think we were having a really interesting conversation. I like the term about, I think you said socializing 2664, and we're kind of moving to the humanitarian diplomacy side of things. So in as much as to the extent to which 2664 has already been implemented at EU level, so only with regard to UN sanctions, I think this is a moment for you to say, Ireland, what would really be useful is if you were to put out guidance on what it means, including guidance to the banks, for example, to other private actors, and say, this is what it means. This is also the opportunity for an actor like Ireland to say, this is what I think is covered by activities to meet basic human needs. It's Ireland. It's not going to be stuck with what France says. So it's almost a moment of opportunity to put out this guidance. And I think it would be phenomenally useful. The UK has been putting out a lot of, the US puts out guidance, and it has become increasingly helpful guidance. The UK started putting out guidance. Am I being recorded? Yes, I am. The UK has started putting out guidance, OPSI. Sometimes it's not as helpful as it could be, because it's like, what's the point of guidance if it doesn't actually say anything? And you know, it depends on your relationship as humanitarian actors with the Treasury, because it's going to be principally the Treasury as we're talking about financial sanctions. It's your engagement with this particular actor and the dialogue in saying, this is the kinds of things that could usefully go into the guidance. So I'd say definitely in terms of the next steps in the implementation of 2664 within Ireland, I think this would really be a very helpful product, if it can be helpful. I mean, there's been a couple of times that I've kind of said, look, better that they don't put that guidance out than if they put that one, what's written at present. So that's very much at Irish domestic level. I would say the last point that I wanted to make is at EU level, because now is a moment of opportunity, because the same legal concerns and the same humanitarian concerns that led to the adoption of the exceptions for UN sanctions are equally applicable when it is the EU that adopts autonomous sanctions. So when it's adopted sanctions in context in relation to which the UN hasn't acted, at Syria, Ukraine, Myanmar, and so on and so forth. So I think the next step in our ambitions should be to include similar safeguards in the EU sanctions. Now, that's going to be challenging politically, as I was talking about the pendulum. I think that when it comes to sanctions, because of the tensions over Russia and Ukraine, things have become extremely politicized in Brussels. So I'd be delighted to be proven wrong again. I don't think we're going to suddenly have a cross-cutting exception that applies 2664 to the EU's autonomous sanctions. I suspect this is going to be something that's developed sanctions regime by sanctions regime. That's fine. Let's build trust that way. But I'd say it would be really important for Ireland to take this forward, obviously in the same way as you were crucial in providing Ireland with the reliable ammunition in New York. It's fundamental that it also continues at Brussels level. I think something we need to be very careful about is that we don't lose the breadth of 2664 that we now have for UN sanctions in EU law, so that it covers both humanitarian assistance and activities to meet basic human needs. it would, and it's that second strand that I suspect is more delicate. Why do I say that? Just because I know that France has been quite opposed to that, to anything that's development. We haven't got it in writing, but that's where they're at. So it would be regrettable if that were lost. So I think there needs to be a lot of strategizing that needs to happen. Ireland, and I'm thinking of like-minded states in Brussels are definitely the Netherlands, Sweden probably. Norway isn't within the EU, of course, but is forward thinking on this, and I think is thinking of adopting cross-cutting across its own sanctions. So it tends to adopt EU sanctions, but it's master of its own destiny. So it's possibly going to adopt it across there. So it could be a valuable precedent, maybe Belgium. So one of those like-minded strategizing how to take this forward strategically at Brussels level. And I think I'm going to stop here for now.
Great. Thanks so much,